আপন বুকের পাঁজর চালিয়ে নিয়ে একলা চলো রে, যদি তোর ডানাতে কেউ না আসে তবে একলা চলো রে। একলা চলো, একলা চলো, একলা চলো, একলা চলো রে।
Hi guys, there is a debate happening around India's proposed FCRA amendment that needs to be stripped of the noise. 3 American politicians have raised objections. Republican Senator James Risch, chairman of the Senate Foreign Relations Committee, has called India's FCRA framework onerous and opaque, quote unquote, and raised concerns about the treatment of US-linked Christian ministries. Congressman Chris Smith has urged Secretary of State Marco Rubio to pressurize India to withdraw the amendments. He has argued that the bill could result in the expropriation of property belonging to Christian organizations. Congressman Riley Moore has described the proposed changes as a clear attack against Christians and warned that churches and religious charities could come under government control. These are serious claims. They deserve a serious response. The first principle is simple. India has the sovereign right to regulate foreign money entering India. The FCRA is not a law regulating Christianity. It is not a law regulating Hinduism. It is not a law regulating Islam. It regulates foreign contributions. If an organization in India wants to receive money from outside India, the Indian government has the right to establish the conditions under which that money can be received and used. That is not an exceptional principle. It is the normal function of a sovereign state. Now consider the American objection. Senator Risch calls the Indian framework quote-unquote onerous and opaque. The United States itself has FARA, the FARA, the Foreign Agents Registration Act, under which certain people acting on behalf of foreign principals have to disclose their relationships and activities. America recognizes that foreign money and foreign influence can create legitimate national security and transparency concerns. India recognizes exactly the same principle. The difference is that India is now applying it to India. There is nothing inherently anti-democratic about that. The second argument concerns property. Chris Smith has warned about the possible expropriation of Christian institutions. Here, the details matter. The proposed bill creates a designated authority to manage assets created from foreign contributions when an organization's FCRA registration ceases. That can happen through cancellation, surrender, or failure to renew. But this is not a provision saying that the government can simply walk into any church and seize it. The bill provides for provisional vesting. If the organization gets its registration restored within the prescribed period, the assets and unused foreign contribution are returned. Okay. Permanent vesting, comes only if the registration is not restored within that period. And the bill provides for judicial appeal against the designated authority's order. There is another provision that is particularly relevant to the American argument. If the asset is a place of worship, the designated authority is required to preserve its religious character. So the claim that this legislation simply gives the Indian government a power to convert churches to government property is not what the text says. There can be a legitimate debate about whether permanent vesting is too broad. There can be a legitimate debate about the safeguards. There can be a legitimate debate about the standard for cancellation and non-renewal. Those are arguments worth having, but those arguments belong in India's parliament and India's courts. They do not become arguments for American control over Indian legislation, right? And then there is the argument that this is an attack on Christians. That claim requires evidence. If a Christian organization receives foreign contributions, it has to comply with FCRA. If a Hindu organization receives foreign contributions, it has to comply with FCRA. If a Muslim organization receives foreign contributions, it has to comply with FCRA. If a secular humanitarian organization receives foreign contributions, it has to comply with FCRA. The regulatory trigger is foreign contribution, not religious identity. And the government's revised FCRA framework explicitly recognizes faith-based activities, including maintenance of places of worship, religious education, moral instruction, meditation programs, and preservation of faith traditions. So the correct question is not whether an organization is Christian. The correct question is whether the organization is complying with Indian law. The distinction matters because there is a broader principle here that Indians should not be embarrassed to defend. Foreign funding is not a fundamental right. Nobody has a fundamental right to receive unlimited money from foreign sources and spend it in India without regulatory oversight. India has legitimate concerns. How much money is entering India? Who is sending the money? India has legitimate interests in knowing all of these broad issues. Which organization is receiving it? What is it being used for? What assets are being created with it? Is the organization complying with conditions under which it was permitted to receive that money? Or is it doing something else? These are ordinary questions of governance. And foreign funding becomes particularly relevant when money is being used to create institutions, influence public policy, operate political campaigns, or build long-term organizational infrastructure. The government has a legitimate interest in knowing what is happening. That doesn't mean every foreign-funded NGO is suspicious. It doesn't mean every Christian organization is suspicious. It doesn't mean foreign philanthropy is illegitimate. It means foreign money is subject to Indian law. That is the entire principle. And now we come to the most important part. America is entitled to disagree with India. James Risch can criticize the legislation, Chris Smith can oppose it, Riley Moore can raise concerns about Christian organizations. They have every right to do that. Indians should hear those arguments. But criticism is not authority. The United States does not get to determine the laws of India, and India does not get to determine the laws of the United States. That is what sovereign equality means. The FCRA bill is currently a proposal before the Indian Parliament. It has not become law. So, if American lawmakers believe that a particular provision is unconstitutional or excessive or discriminatory, make that case. Identify the provision, explain the legal problem, provide the evidence, let Indians debate it, but don't turn disagreement into an assumption that Washington has veto power over Indian legislation. That is where the argument crosses the line. India is not an American dependency. India is not a protectorate. India is not required to obtain approval from Washington before regulating foreign money. And there is no contradiction between being pro-American and defending Indian sovereignty. In fact, a strong India-US relationship requires exactly this kind of mutual respect. Two democracies can disagree. Two democracies can regulate foreign influence differently. Two democracies can defend their own national interests. America does it. India can do it too. And if the FCRA bill contains provisions that need improvement, improve them, strengthen due process, strengthen judicial review, clarify the powers of the designated authority, prevent arbitrary action, protect legitimate civil society. Those are reasonable demands, but the answer to a flawed Indian law is better Indian law. It is not American supervision. So, India should listen to America's arguments is an impossible position. India should examine the evidence. India should fix anything that is genuinely wrong. But India should make its own decision. Because the money is entering India. The organizations are operating in India. The assets are located in India. And the law is being made by the Indian Parliament. If America has FARA to regulate foreign influence in America, India can have FCRA to regulate foreign contributions in India. That isn't anti-American, it isn't anti-Christian, it isn't anti-democratic, it is sovereignty.
আপন বুকের পাঁজর চালিয়ে নিয়ে একলা চলনে যদি তোর ডানাতে কেউ না আসে তবে একলা চলো একলা চলো একলা চলো একলা চলো একলা চলো রে